Let's go on the record on cause number DC 2010520, Vetter versus Shavasan, MD. Counsel, make your appearances.
Ryan Snow for the plaintiff.
Lee Buckstein for defendant, Dr. Chavison.
Russ Thornton for defendant, Joel Hollander and Joel Hollander, MD-PA.
All right, I've read the briefing on this. It was very interesting. Let's get started.
Your Honor, this is Lee Buckstein. Mr. Thornton, did you want to start or did you want me to go first?
Doesn't make any difference to me.
Okay, I'll go first. Try to make it brief. This is a motion to dismiss the lawsuit on the basis of failure to comply with Texas Civil Remedies Procedures Code Section 74. The lawsuit is a lawsuit largely under Section 81.03 of the Civil Practices and Remedies Code. The Texas legislature and their tort reform efforts decades ago gave the healthcare providers of Texas an advantage at the beginning of tort claims against healthcare providers. The legislature created a barrier right at the front end of litigation, a medical expert report. And for physicians, it is absolutely required that the expert report be the expert report of another physician. The legislature giveth and taketh away. The Texas legislature later lengthened the statute of limitations for this limited category of tort claims under Section 81.003 against healthcare providers that directly arose from their activities as healthcare providers. There is no relief from the requirements of Section 74 of the Texas Civil Practices and Remedies Code for cases filed under the auspices and statute of limitations in Section 81.003. The Section 81.003 cause of action and lengthened statute of limitations does not reach anyone who is doing the exact same objectionable things unless they are healthcare providers. Sometimes healthcare providers rear-end vehicles. Sometimes healthcare providers create conditions that cause people to slip and fall. Sometimes healthcare providers trespass when they go hunting for quail. Those kinds of torts disconnected from the healing arts are not subject to an expert report per Section 74. But that is not what the plaintiff's case is about. All of the Texas precedents that apply to this situation reinforce the statutory requirement of Chapter 74 compliance with actions under Section 81.003, unless the claim arises for conduct that is distant from the healthcare provider's activities as a healthcare provider. The allegations of this former patient against Dr. Chavison and the Hollander Group are all directly, closely connected to Dr. Chavison's activities as a psychiatrist, seeing the plaintiff in the medical practice setting. Even the alleged lobby run-in was when the plaintiff, on her way to see one of the Hollander Group doctors or mid-level practitioners, encountered Dr. Chavison when he was traveling between locations at the healthcare practice site in the course of his activities there as a healthcare provider. The plaintiff's hanging on to the case before the Texas Medical Board at the State Office of the Administrative Hearings is specious. It does the opposite of what plaintiff contends. All of these allegations and procedures from the Texas Medical Board are within the jurisdiction of that entity to regulate Dr. Chavison in his activities of the practice of medicine. The Texas Medical Board's authority does not extend beyond allegations that Dr. Chavison violated statutes and board rules regarding the practice of medicine. The case at SOA ties the plaintiff's allegations even more tightly to the practice of medicine. Even the plaintiff's allegations of fraud are tied directly to fraud in the practice of medicine. Because the plaintiff is making claims which are all tied to the practice of medicine by my client and by the Hollander Group as a client, plaintiff's undisputed failure to comply with the requirements of Section 74 required dismissals of these claims with prejudice. I pass.
Are you still there?
I passed to the next, I guess, Mr. Thornton to make his presentation.
Yes. You want me to go now, Your Honor?
Go ahead.
Yes, okay. I represent Dr. Holliner and the Holliner Group. And, since you've read the briefing, I'll cut to the point on them. There is.
I guess my question is, and this is, I guess, good for either of the defense attorneys. So you're saying that if a doctor asks a patient out or sexually exploits or sexually harasses a patient anywhere, that would be the rendition of medical care?
Well,
I have not said that, Your Honor.
Then how do you say that when he ran into her at a cupcake shop, that was somehow the rendition of medical care?
We're saying that that's the rendition of medical care because it's in the practice setting.
The
He's
cupcake
working
shop?
there. She is coming there to see another physician or one of the mid-level practitioners. And the cupcake shop, which is not, all respect, Your Honor, they ran into each other in the lobby of the facility.
I thought it was in a cupcake shop. No?
No, Your Honor, it's in the lobby of the hospital.
Okay. Was she not going to get coffee?
She was there to get medical care. She was in the lobby of the hospital. She was on her way to get medical care, not from Dr. Chavison. She no longer was seeing him, but from one of the doctors of the Holliner Group.
And so just because she was in the hospital, it becomes medical care?
It's in that setting. Yes, Your Honor.
Okay. So, I mean, there's been quite a few cases about this. Like a slip and fall in a lobby of a hospital isn't generally the rendition of medical care. Why would this be the rendition of medical care? Just because it's in the hospital?
So let me, Your Honor, could I
Go ahead.
step in here quickly?
Sure.
So two things. First of all, let me just, with respect to my client, the allegation has to do with negligent retention of Dr. Chavison. So if you look on page 8 of the petition, page 8 and page 9, the allegation is that my client was negligent in retaining Dr. Chavison. And, the Supreme Court in 2 cases, in Ray McAllen Medical Center, which you have, and in Garland Community Hospital versus Rose, Texas Supreme Court said that the negligent retention of a healthcare provider is a healthcare liability claim. So first of all, with respect to the allegations against my client, that is a healthcare liability claim. Now, to go to Mr. Buckstein, the point that you were talking about in terms of the circumstances, the allegation that you're talking about in the cupcake shop is the last time Dr. Chavison and the patient crossed paths. And every single time during the years before then, as the patient alleges in her petition, she was seeing Dr. Chavison as her physician. And so just because one of multiple times that they had interactions was outside the physician-patient relationship doesn't mean that this isn't a healthcare liability claim. Because and she says it in her petition, this is not, that she was seeing Dr. Chavison as her physician, and that her interactions with him were in the context of a physician-patient relationship. And those are the statements that are in her petition. And what the Supreme Court tells us in the Loisaga versus Serta case is that if under the facts there could be a claim for violation of medical standards of care, then it's a healthcare liability claim, even if those standards are not alleged to be violated. And so the issue here is that she is claiming he did things inappropriately within the context of the physician-patient relationship. And so you can't, This gets into the claim splitting too. Okay, you can talk about the cupcake shop or the coffee shop or what have you, but that's not the only issue at hand here. With the exception of that, every other contact, every other issue has to do with within the context of the physician-patient relationship as she's alleged. And so you can't split it out. We might have a different story if her only complaint was, well, he asked me out, in the cupcake shop after our physician-patient relationship ended. And then she might have an argument based on, the Nexus case, because that's what the Nexus Recovery Center versus Mathis case was about. It was about something that happened solely after the physician-patient relationship was over. That was the complaint there. There was no complaint about actions while the patient was at the facility.
I will add to Mr. Thornton's statement that the Nexus case is about how an occurrence that's distant in time and location, and that's an important part of the Nexus case. It's distant in time and location. And this run-in in the cake, well, nothing before that, but this run-in in the lobby of the hospital when the plaintiff is coming from the cupcake shop there, or the coffee shop and getting cupcakes. This is not distant in time, and it's not distant in location from the practice setting where she has all the other interactions with Dr. Chavison.
All right, let me hear a response from the plaintiff.
Thank you, Your Honor. I disagree with my opponents. This is a sexual exploitation case. The deposition testimony by Dr. Chavison and Dr. Joel Hollander in the SOA case shows them admitting that this is not medical care. So it doesn't matter that Dr. Chavison was in the medical care setting when he was telling my client some fairly inappropriate things, such as offering, to perform oral sex on her, offering to, meet with her outside of the office for a sexual relationship and things of that nature. So there's also case law from the Supreme Court that says just because something happens in a medical context doesn't mean that it's healthcare. And I think it would be hard to argue that sexual harassment is medical care. So this is a Chapter 81 case. And the fact that there's a few tangential details that might relate to medical care is really inapposite here, because what the courts look to, and this is in some of the case law cited by the defendant, this is cited in Mathis, is that the courts look to the gravamen of a claim when determining whether the Medical Liability Act at Chapter 74 applies. And the gravamen, according to Black's Law Dictionary, is the essence of a claim. And the essence here is his sexually harassing and sexually exploitive comments to the plaintiff. I would also point out that I don't think Losaiga versus Serta completely resolves this case in the defendant's favor. It is page 257, where the Texas Supreme Court says that a claim against a medical or healthcare provider for assault is not a healthcare liability claim if the record conclusively shows the three things that the defendants rely on. So I don't think Losaiga versus Serta fully resolves this. I think at a minimum, this case should go forward. The timing of this motion is a little bit unfortunate because next week, the SOA case starts against Dr. Chavison, and shortly after that is mediation. So I think this case deserves to live on and see another, see beyond today.
Okay. Response?
I wanted to make sure Mr. Snow was finished before.
Yes.
Just raise my hand and let you know.
Go ahead.
Okay. Three things, actually. I have an acute kidney stone that is causing me great pain. I asked for a continuance of the SOA trial, and it was granted this morning. So the trial is not going to be conducted as scheduled starting April 16th. It won't be until September. The second thing of three things is Mr. Snow inaccurately characterized Dr. Chavison's testimony and Dr. Holliner's deposition testimony when he said that they stated that it's not, that what Dr. Chavison is accused of is not medical care. It was in the context, if you read the deposition, they were testifying that it was not appropriate medical care, that it's not within the appropriate conduct of a doctor. And the last thing is assault. Dr. Chavison hasn't been accused of assault here by the plaintiff. He's been accused of harassing her. Her deposition testimony is that he never touched her. I mean, she said he wanted to hug her, but she never let him hug him. So there's not any accusation or even evidence that Dr. Chavison was either accused or committed some kind of assault against this particular plaintiff.
Your Honor, if I may.
Let me ask a quick question. So I just read a little excerpt from the Nexus recovery case. Are there any other cases that kind of interpret 81.002 in context, or any other cases that deal with Section 81 in context of whether or not an expert report is needed when it comes to a Section 81 cause of action? What are some other cases that talk about that?
None that are binding on Your Honor. There's one from a different court of appeals, NCED versus Kidd, I think.
Yes.
And that case is opposed and says that there, is an expert report that is necessary, but I didn't feel the need to cite that because it's not binding on Your Honor. And the Nexus case is a Dallas Court of Appeals case. But I would just say quickly in response to Mr. Buckstein, we haven't alleged assault. He's correct about that, but there's regulations that are quite close to the statutory Section 81 definition of sexual exploitation, and those regulations give examples of what could constitute sexual exploitation. And so the fact that it was just pervasive comments in that setting, I would submit still amounts to a sexual exploitation case and not a medical malpractice case.
So the only binding precedent that really covers this cause of action is it the Nexus recovery case? There's nothing in the Supreme Court either that's interpreting that particular section? As
far as I'm aware, I haven't seen anything else. And that's why I highlighted in one of my responses to the, I believe it was to Defendant Chavison, that when the Texas legislature was enacting this, they were doing this because there's a lot of underreporting of sexual exploitation. And I certainly believe that to be the case in light of the scant case law that I've been able to find out there that directly deals with this issue. There's only one other case that I was able to find, but I don't think it's really dispositive of this case. There's a more recent case from the San Antonio Court of Appeals, Wolf versus Storrs, but I don't think that really answers too many questions here.
Your Honor, I would say that there's two controlling cases. First of all, again, talking about the narrow claim that's against Dr. Holliner's group, which is negligent retention and supervision. The In Ray McAllen Medical Center case, Texas Supreme Court case from 2008, says that is a healthcare liability claim. And so there's no authority that anybody.
But doesn't that assume that the underlying conduct is medical care?
No. I mean, the issue is the negligent retention of a healthcare provider, and the claim against my client would be just like with a hospital in retaining a physician. You know, there's standards that relate to retaining healthcare providers, which are different than standards that relate to retaining non-healthcare providers. And the Supreme Court said it twice. Also in Garland versus Rose. The other thing that I would point out is that the Mathis case came out not quite a year before Loisaga, and Loisaga directly addressed, you know, sexual claims. Now, in that case, it was a sexual assault based upon a doctor groping two women's breasts during an exam related to the flu and related to sinus problems. And in that situation, again, the court made clear the presumption is that it's a healthcare liability claim if something happens within the context of the physician-patient relationship. And the allegations in the petition make it clear that she's complaining about what happened in the context of the physician-patient relationship. So I think, and there's complaints about, well, he diagnosed me with bipolar disorder. He wasn't documenting appropriately. There's a complaint against Holliner that we violated a statute that the Texas Medical Board establishes relates to healthcare providers specifically. And so those things, the elements are there. And you know, obviously.
I do agree if there's something related to how medical. So you're saying one of the allegations that he makes is that they failed to document certain things. Is that correct?
Yes, sir.
And I would think that would be covered by, that would clearly be the rendition of medical care. If you can't kind of have your cake and eat it too, Mr. Snow. And so I would think at least that portion of the cause of action should be dismissed.
Okay. Well, then, you know, that tangential fact doesn't factor into really any of the causes of the 5 causes of action that we have. So I understand that. You know, if anything, there was a case Your Honor presided over about 10 years ago, Nexian versus Ross, where Your Honor dismissed 2 causes of action against a healthcare provider and left a lot of others. Your Honor was affirmed on appeal. If there's any kind of dismissal here, I would argue that it should be, you know, limited, similar to the Nexian case.
Sounds like I was very wise.
Yeah, Your Honor, if I may speak.
Sure.
Yeah. Mr. Thornton has cited the Loisaga versus Sergey case. I think that makes it clear, that case makes it clear that anything within the medical care setting is part of medical care. And there, it wasn't until it was conduct that was on the level of assault. What a psychiatrist is saying to their patient during the medical care, however inappropriate, that's not what we're discussing right now, is how inappropriate it was. However inappropriate, if it's part of medical care, and that's the substance of what the Texas Medical Board is pursuing Dr. Chavison about, it's a healthcare liability claim. It doesn't have to be Loisaga is clear, and the discussion of Loisaga makes it clear that it doesn't have to be a medical malpractice claim in order to get dismissed for failure to have the expert report under Section 74.
All right, so first off, I do think this is kind of a close call on a lot of this. It could really go either way. There obviously isn't a whole lot of guidance from the Court of Appeals, and so I have to kind of predict what I think our current Court of Appeals would do here. And so let's kind of parse this down. So what I think clearly would not be covered by this and will not require an expert report would be any of the, I understand your argument about distance, but any of the behavior that was engaged at the cupcake factory or cupcake, whatever it is, place, you know, kind of know what it is, that is not going to be dismissed. So that's one area that I can say, I know I'm not going to dismiss. On the other hand, anything dealing with, you can't have your cake and eat it too, Mr. Snow. So we're talking a lot about cakes. I kind of want dessert now, but the cupcakes and the cake here. But so anything related to charting, clearly that's the rendition of medical care. And so failure to chart, that would be covered. That is something the doctor has to do. That's clearly covered by the rendition. So any charting claims that should be dismissed. So where we get into kind of the in my mind, the grayer area is everything kind of in between. And so, so Mr. Thornton, kind of let's go through, or Mr. Snow, let's go through the different causes of action that we have here. What else are you moving to dismiss on, given kind of the scenario, the parameters I've set here, Mr. Thornton? What else are you moving to dismiss on?
Well, with respect to the only claims against Holliner and his group are for the negligent retention and supervision of Dr. Shavison.
And part of the supervision was the failure to ensure that he properly charted. Isn't that what you said?
No, the claim against him is one, just that we didn't fire him sooner. In two, there was like a practice supervision agreement, and that we should have known that wouldn't be sufficient to prevent him from doing what he did, allegedly. So those are the two claims against, and it relates to the supervision of a physician, or the retention of a physician, which again, that's why I go back to N. Ray McAllen Medical Center.
But why did you talk about charting, I guess? How was that?
I was answering a broader question, with respect to the gestalt of the whole case, as opposed to just the claims against.
If I may interject, Your Honor, there's the allegation that's connected to one of the causes of action that my client fraudulently, falsely diagnosed this patient as having a particular mental health diagnosis.
That I think would be covered. I agree that would be covered by, that would be medical care, and that would need to be dismissed.
Yeah, and also accused him of not recording information, or not recording information. I mean, that's in there too, about weight, and that's part of the allegations, that somehow that was
I don't understand that, not recording weight.
Well, it's part of the fraud, I guess.
So the diagnosis of bipolar disorder is medical care, even though he admitted to the plaintiff that he was just trying to give her that diagnosis so that he could bill the insurance to spend time with her. I understand how most of the time a fraudulent diagnosis of bipolar disorder would be medical care. But in my latest reply, I filed deposition excerpts from the plaintiff where she talks about that very interaction with Dr. Chavison and confronting him about the false diagnosis. And he plainly admitted to her that she didn't qualify for it, and he was just using it so that the insurance would pay him. That doesn't sound like medical care to me. That sounds like insurance fraud. So under most circumstances, yes, I can understand.
Wouldn't that be a cause of action the insurance company would have against him, not a claim that you're, I don't know.
Well, yes, it's not a claim that we're making against him. There's no like false claims or anything like that. It's a private healthcare insurance company. But I'm just saying, I don't see how that should qualify for medical care. It's not a cause of action, but under the particular circumstances of this case, I don't see how that's medical care.
It's the basis of their allegation that there's a fraud cause of action, Your Honor.
We've asserted a breach of fiduciary duty. We have not asserted any kind of fraud action.
Let me look it up. We're all kind of. When was your most recent petition filed?
The petition itself is only the original petition.
Okay.
That we have, and we're definitely inclined to file an amended petition here in the near future.
I mean, I've got to look at the petition as it stands. So let me.
Your Honor, it was filed August 3rd.
I think this is it. I got it, yeah.
Yep, there you go.
So let's look at the different causes of action. Is the first one is violation of 81.002. Do you see that on the screen?
Yes.
Okay, I'm going to deny the motion to dismiss as the cause of action number one. This is a tough call as to Hollander, I think, or tougher call. I think they're both tough calls, but for Hollander, that he had reason to know and to take necessary steps, I'm going to deny as to that. Failure to report, I do think that's medical care, so I'll grant as to that. What is a performance improvement plan? Was that part of what he was going through, the performance improvement plan?
Yes,
Correct,
that was.
yeah.
Yes, that's what Dr. Hollander put Dr. Chavison on, and Dr. Chavison failed to live up to what was required.
That's not something that was required by the medical board.
Correct.
Okay, so that's denied. Okay, those are the only causes of action there. Breach of fiduciary duty.
Your Honor, I'm sorry, I'm misunderstanding.
Let me finish making my rulings and then I'll hear from you again, okay? So let me just finish making my rulings. For breach of fiduciary duty, as to making the sexually inappropriate comments, that's generally going to be denied. So the summary, that motion to dismiss is denied. For breaching the duty by giving her a false diagnosis of bipolar disorder, I'm going to go ahead and grant. And then intentional infliction. That's just because of the diet. I'm going to go ahead and grant. The motion dismisses that. And as the negligent retention, I will deny. Okay, I'm sorry. Now, Mr. Buxton, you wanted to say something? I'm so sorry.
Well, I just want to make sure I understood when you are saying deny, you're denying the motion to dismiss.
Correct. I'm sorry. Yes, that was a little unclear. The motion dismissed for those who are denied. So did you guys take notes on that? So it's clear, because I'm going to have Mr. Snow prepare an order on this.
Yes, sir.
Okay, so the 81.002 and 81.003 survive, and then the breach of fiduciary duty is partially dismissed. And
yeah, so okay, I'll try to go through it again. For cause of action number one, completely denied. Cause of action number two, denied, except as to failure to report to the Texas Medical Board. That would be granted. Breach of fiduciary duty is denied, except as to the false diagnosis of bipolar disorder. Cause of action number four is granted in its entirety. Cause of action number five, it's denied in its entirety.
when would Your Honor like this?
So this, this is what I'd like you to do is prepare the order, make sure on the order it says, instead of at the beginning where it says on this date, the court made the following rulings, put on April 12th, 2021, the court made the following ruling. So it's clear what date this was decided. And then share that with the other side. It'd be great if we could get it approved as the form. If not, then just submit it without an approval as the form. And then email my court coordinator as well as e-filing this.
Okay, I will do that.
Any other questions, guys?
No, sir.
None, Your Honor.
All right, you guys be safe. I hope you feel better, Mr. Buckstein. I'm sorry about you going through that kidney stone.
Thank you.
Thank you.
All right, you guys be safe.
You too.
Thank you.
All right, are you guys all here on the Luther Preston Center case?
I'm here, Judge. I think I saw Boyd Mouse on here as well.
Hello, Your Honor. Boyd Mouse for Polaris Operating.
All right, so you guys had moved for a continuance, is that right?
Correct, Judge. This case is old, and I acknowledge that, but we had some problems early on with the defendant producing documents and answering discovery. Since that time, Mr. Mouse has substituted into the case, and it looks like we've got it back on track, but we need a little more time. And what we had discussed, just because we have piling up trial settings in other cases, was to try to do it in October.
So let me kind of tell you the issue I have with this, and we can, kind of talk about it. Is you guys have probably heard, I imagine, that the civil district courts, as well as the other courts here at the George Allen, have set a trial schedule for the jury trial schedule for live jury trials during the summer. And so each judge has been, for June and July, essentially, I'm simplifying this quite a bit, but been assigned one date in June and one date in July where they can pick juries. And so and then after that, I believe we're going to be starting, believe, if everything continues to go the way it's going, that we're going to be starting up jury trials on a more robust basis. And so from a scheduling standpoint, is this going to continue to be a non-jury case, do you anticipate?
The plaintiff at this time believes it will be non-jury, yes.
Your Honor, I believe so. I can't say with 100% certainty, but I'm pretty certain.
So what I would suggest, if this could work for you guys, and if it doesn't, then we can kind of talk about it, is let's maybe set this, my jury trial date in July is the 19th. What if we did like July 13th, maybe? I'd like to do it on a date that I know I'm not going to have a jury trial, because once we start jury trials, we're just going to be, as you can imagine, we have a massive backlog. Would July 13th maybe work for you guys, or maybe sometime in June?
Well, on the plaintiff's side, other than a vacation I have the first week of June, we would be fine. Mr. Mouse had expressed to me that I think he had some vacation plans in July.
When is your vacation in July?
The last 2 weeks, well, actually starting on July 16 to the end of the month.
How long will this trial take to try?
A day.
So would July 13th then work? Let me double check. I want to make sure I have the date right. I'm pretty sure it's the 13th. Yeah, July 13th.
That would work for me, Your Honor, provided that we can get, reached and tried that day or a couple days, within a couple days.
And Mr. Mouse, just because I know how I am, do you have a light sensor there, Mr. Walker?
I do. I apologize.
Or is that a bug? I couldn't tell if you were chasing a bug or waving your arms.
Apparently I wasn't moving enough to keep the lights on. So
that's happened to me here in the courtroom before. I'm working away and on my computer, and then all of a sudden everything turns, you have to kind of wave your arms. So, so Mr. Mouse, I obviously do not want you to miss your vacation. So if we get to July 13th and I start talking about, schedule, moving you back so that interfere with your vacation. Please understand that that's because I've forgotten about this conversation, and I don't want to affect your vacation. I want you to be able to see your family and all that kind of stuff. And so, but that being said, July 13th would be a good day for me. It sounds like a good day for you and for Mr. Walker. So, so let's do July 13th if that works. Have you guys already been to mediation on this case?
We haven't, and that's something we need to do.
Have you all figured out a mediator?
I believe you appointed Mr. Nuss.
That's
Yeah.
Bob.
Yeah.
Is that who you want to use, or do you want to use someone else?
I have never used him, so I don't have any impression one way or the other.
Same here.
I'm sure he'd be fine, but if there's somebody else that you prefer, I'm pretty flexible.
Not having availability for any of those other mediators, but I mean, certainly there's, a number of people we'd be happy using. I'm happy to talk to Mr. Mouse about that.
Okay. You guys get along okay?
Yeah.
Sure.
All right, I'm going to go ahead and sign the continuance to July 13th. And I anticipate, this, I don't know for sure, but this will probably be over Zoom, just FYI. But if you guys really wanted it, let me just, sorry, I'm having some problems here. Let's see. Okay, I'm printing it out right now. Max, do you mind grabbing this order? And anything else we need to chat about, guys?
No, I just wanted to let you know, Judge, my client's probably going to move for summary judgment. I assume we'll have plenty of time to get that heard before.
Yeah, before July 13th, absolutely. But don't wait too long.
Okay, super.
All right, anything else, guys?
No, Your Honor.
All right, you guys be safe, okay?
Thank
Judge.
you.
All right, our next hearing, I'm sure that Mr. Stillwell, that's what you're here for. Are you guys here on the Parker v. Doyle case?
Yes, Your Honor.
Okay. Do y'all want a record on this?
Yes, please.
Okay. Tony, let's go on the record on cause number DC 208352. Parker v. Doyle. Counsel, make your appearances.
Sikander Muir on behalf of the plaintiff.
Mr. Stillwell, are you there?
I was muted. John Stillwell on behalf of Allstate. Sure, a lot of people would like to mute me, so I'm muted.
Is this everyone on this case? Because there's another person signing on.
I believe these are the only two counsel on the case so far, Your Honor.
There's someone just signed on with the last three digits, their phone number 884. Who is that?
I'm not sure, Your Honor.
Whoever that is, if you could unmute, I just want to make sure that we know what you're here for. The person on the phone, could you unmute, please? Well,
I don't think they're for our case, Judge.
okay, well, let's go ahead and go forward then. Mr. Mayor, if you can, he just signed off anyway. Go ahead and go forward with your argument. I've read the briefing.
Yes, Your Honor. So, Your Honor, this is just a motion to compel the oral deposition of the corporate representative of defendant Allstate. In this case, we've sued the party that we allege to be at fault for the accident, as well as the first party carrier Allstate. So far, the potential at fault party or at fault driver has not made an appearance in this case. The only parties that have appeared in this case so far are the plaintiff and defendant Allstate. Now, before today's hearing, Your Honor, I did confer with opposing counsel. We have generally agreed to limit the scope of the deposition to the 4 topics that have been outlined in the In re Allstate decision. And those 4 topics would form the basis of our oral deposition. We have also
In re Allstate case or in re State Farm case?
In re Allstate, Your Honor, out of the Court of Appeals of Houston.
Okay.
And those 4 topics would be the that the insured had coverage or that the plaintiff had UM/UIM coverage at the time of the accident. The topic would also delve into liability for the underlying accident itself and the amount of damages, as well as that the other drivers or the at-fault drivers' insurance coverage was deficient. Those would be the four general topics we would delve into. And based on our conversation before the hearing today, the parties have tentatively agreed to schedule a hearing for May 27th, or I'm sorry, a deposition for May 27th. And that's the party's intent at this time.
That sounds good. Mr. Stillwell, is that agreed to?
Well, it's the scope that generally it's agreed to. I think the asking questions about the damages, I don't think the In re Allstate authorizes that. Although I have told them that I think it's fair game to ask about witnesses that we, that the adjuster may know about, or any affirmative defenses that have been pled, which there hasn't been a pleading of contributory negligence or anything. So, but yes, coverage, offsets. There aren't any offsets, I don't believe. Coverage, premiums paid, the existence that this is a covered event. I think all that's fair game.
All right.
And the In re Allstate, like you talked about, I think at the time the court denied our motion to sever and abate, I think it was there was a question maybe about severance and abatement based on those cases where they sued for insurance code violations only. I think the In re Allstate, In re State Farm, I apologize, I clarified that, I think, a few weeks ago. And so we had tried to file a motion to reconsider the denial of the severance and abatement. I know the court and myself had another hearing where you did grant it consistent with what Judge Moldberg had granted in another case, but I'm not exactly sure what happened in this case. Motion to sever and abate.
So, Mr. Stillwell, are you talking about something else that's not set for today, or what are you talking about?
I guess it's technically not set. So yes. So
if you guys want to submit an agreed order on this, I'd be happy to sign it. If I'm of course going to follow what the Supreme Court requires me to do, and so if you guys want to submit an agreed order reconsidering or modifying my previous order, I'm happy to consider that. If there's not an agreement, then obviously we need to have a new hearing and
I'll just
look at it.
We'll look at that. But just so I'm clear, and Sikander can correct me, so we're going to take a limited deposition. It sounds like May 27th is the date that we've tentatively agreed upon to take the plaintiff and the corporate rep. And then we're going to talk about the policy issues and the liability issues and the things I think we discussed. I think the only question is how far can we go with the approach that. Go do the deposition.
It's very hard to hear you, Mr.
I'm sorry. But maybe the best approach is we take the deposition, and if there's any issues, then we can come back to the court and ask for guidance on that.
I think that's a great idea.
And I will say this on the record on behalf of the plaintiff that yes, May 27th is the tentative date. I will say on the record that we will limit our deposition to the topics outlined by the Court of Appeals of Houston and the In re Allstate case. And the party does that.
Then we should be great. That would be perfect. As the court may be aware, the Supreme Court has heard recently, but I think the In re Allstate is a fair decision. The Supreme Court heard a USAA case. I don't expect that decision to come down as quickly as June 27th. So that'll apply to another case probably.
Sounds good. All right. Well, great. Good seeing you guys. I guess I don't really need an order. Is that you guys have kind of just reached an agreement?
I think we have.
Yes,
like we said, I think if there's a problem, we can come back to you, Judge.
Sounds good. Great to see you guys.